Madam Chair, this is Teresa Haley. Staff is ready to begin the meeting when you are.
Yes, ma'am. Thank you very much. My name is Patsy Bryson. I'm the chair of the Board of Zoning Appeals for the town of Hilton Head Island. At this point, I will call to order the town of Hilton Head Island Board of Zoning Appeals meeting for Monday, May 21, 2021 at 2:31 p.m. Ms. Haley, are we in compliance with the Freedom of Information Act, also known as FOIA?
Yes, ma'am, we are.
Thank you, ma'am. Will you call the roll, please?
Yes, ma'am. Mr. Walzak?
Present.
Mr. White? Mr. White, are you present? I see you're muted on your end, Mr. White. If you could unmute. Okay, we'll circle back to Mr. White. Ms. Loudermilk?
Present.
Mr. Johnson?
Present.
Mr. Fingerhut?
Present.
Dr. Ponder?
Present.
Ms. Bryson?
Present.
And I do see Mr. White is on the line, but he appears to be muted on his end.
Okay, thank you, ma'am. I can now see part of his office area. So
Yes.
Perhaps we'll get Mr. White in just a moment to respond. Ms. Haley, can I ask you, because we are on a Blue Jean call, I'm not able to see all of those who are present. Can you please introduce the staff members and any legal counsel for the town, any town council members that you might see on your screen?
Yes, ma'am. For staff, we do have Miss Ann Siren, Terry Lewis, Nicole Dixon, Missy Lewick, Tyler Newman, Diane Bush, Josh Gruber, Jennifer Ray, and from council, we have Mr. Harkins.
Okay.
And I do see that Curtis Coltrane is on the line as well.
Okay. Do we have the applicants present and represented for the continuation of the public hearing on the variance request that was continued from the April 26th meeting?
Yes, ma'am. I do see we have the Pritchard Law Firm present, and then I do see a Julie Bowman on the screen.
Okay.
Oh.
All right. Thank you, ma'am. The next item on the agenda is to go over board procedures. Today, primarily, we are here for a continuation of a public hearing on a variance application. At the initiation of that public hearing on April 26, 2021, I did review the procedures. Unless there's someone who requests that I review those again, I'm not going to review those in full. I'm only going to say that the variance requirements are found in the LMO or Land Management Ordinance subsection 16-2-103S. And the procedure that the board follows is found in Article 7, Roman numeral 7 of the Rules of Procedure for the board. Most importantly, the board tries to provide a fair and impartial hearing for all applicants and staff by following procedural and substantive due process. And by doing that, we follow the requirements of the LMO, state statute, and also the board's rules of procedure. So that is our process. And unless someone asks me to review those in more detail, we'll go ahead and proceed with the next item on the agenda. I see a hand being raised, and it says Julie Bowman. And I'm not sure who that is.
Yeah.
I think I was muted. My name is Tom Michael. I represent the town as well as Mr. Coltrane.
Okay. So the town is represented by two attorneys in this matter. Okay. All right. Then the next item on our agenda is approval of the agenda. I'm sorry. Are you speaking
Yeah,
again, Mr.
this is
Michael?
Curtis Coltrane. Yeah, in this
Yes,
matter,
yes,
I'm here as an observer. I'm conflicted out of the litigation between the town and Mr. Scott. So, I
Okay.
mean, Mr. Michael just noted that I was also involved in representing the town in this matter. I do represent the town, but not with respect to the specific litigation between the town and Mr. Scott.
Yes, sir. I do recall that from the April 26th public hearing on this matter, which is continued until today. So the town is only represented by Mr. Michael in this matter, is that correct?
Well, Ms. Bush is also on the line.
Okay, all right, thank you, sir. So anybody else want to say anything before I ask for consideration of the agenda today? Hearing none, I will ask if the staff, any board members have any changes to the agenda. Hearing none, can I have a motion to approve the agenda?
So moved.
Mr. Walczak, is there a second?
Second.
Second by Ms. Loudermilk. Any
That was
discussion
John
on
White.
that? I'm sorry, Mr. White?
Yep. Yeah, that was John White.
Okay, all right. Any discussion on that motion? If not, Ms. Haley, will you please call the roll?
Certainly. Mr. Walczak?
For the motion.
Thank you. Mr. White?
For the motion.
Ms. Loudermilk?
For the motion.
Mr. Johnson?
For the motion.
Mr. Fingerhut?
For the motion.
Dr. Ponder?
For the motion.
Ms. Bryson?
For the motion.
Motion
Okay.
carries.
I'm sorry, Ms. Haley. Thank you. Go ahead.
Motion carries 7-0. Thank you.
Thank you, ma'am. I apologize for interrupting you. The next item on the agenda is approval of the minutes. We have two sets of minutes to consider. Our meeting of April 26, 2021, our regular meeting, and a special meeting on April 29, 2021. Are there any changes to either of those sets of minutes? Hearing none, is there a motion to approve both sets of minutes?
Sure, I'll move to approve the minutes, both
Mr. Walt-
meetings.
Mr. Walczak, is there a second? Can I have a second to
Second.
approve the minutes?
This is Bob Johnson. I second.
Thank you, sir. Mr. Johnson, any discussion on the motion? Hearing none, Ms. Haley, will you call the roll, please, ma'am?
Yes, ma'am. Mr. Walczak?
For the motion.
Mr. White?
For the motion.
Ms. Loudermilk?
For the motion.
Mr. Johnson?
For the motion.
Mr. Fingerhut?
For the motion as to April 26, 2021 only. I wasn't present at the special meeting, so I can't participate in that.
Thank you. Dr. Ponder?
For the motion.
Ms. Bryson?
For the motion.
Ms. Haley, this is Lisa Laudermilk. Nor was I at the April 29th meeting. So my motion my approval would support the April 26th minutes.
We have two abstentions. It may be getting a little confusing to try to approve both minutes at the same time. Mr. Walczak and was it Mr. Johnson making the second? Maybe we ought to proceed first with the April 26 minutes. And I'm sorry, Ms. Haley, go back through and call the roll, and then we'll separately do the April 29 minutes.
Yes, ma'am. For the April 26th minutes, Mr. Walczak?
For the motion.
Mr. White?
For the motion.
Ms. Loudermilk?
For the motion.
Mr. Johnson?
For the motion.
Mr. Fingerhut?
For the motion.
Dr. Ponder?
For the motion.
Ms. Bryson?
For the motion.
And as for the April 29th special meeting minutes, would the motion and the second be the same?
Any objection for the motion and the second to be the same by the maker and the seconder?
No objection there. I'll make it again.
And the second by Mr. Johnson.
Yes.
If you'll call the roll then, please, ma'am.
Yes, ma'am. Mr. Walzak?
For the motion.
Mr. White?
For the motion.
Ms. Loudermilk?
Abstain.
Mr. Johnson?
For the motion.
Mr. Fingerhut?
I also abstain. Thank you.
Dr. Ponder?
For the motion.
Ms. Bryson?
For the motion. And so, Ms. Haley, by my account, that motion is adopted as well.
Yes, ma'am.
Five in favor with 2 abstentions.
Yes, ma'am.
Thank you, ma'am. The next item on the agenda is appearance by citizens. Ms. Haley, can you help us out with that?
Certainly. Thank you, Madam Chair. Public comments concerning agenda items were to be submitted electronically via the Open Town Hall portal. The portal closed at 12:30 today, and there were no comments of record. Also, citizens were provided the option to give public comment during the meeting by phone. However, there were no requests to give public comment by phone. Thank you.
Thank you, ma'am. Next item on the agenda is unfinished business. This is a continuation of the public hearing from April 26, 2021 in a variance request entitled VAR-000-818-2021, request from Edward K. Pritchard III for a variance from LMO sections 16-5-102 setback standards and 16-5-103 buffer standards for an existing non-permitted food truck and associated screening fence to remain in the required adjacent use setback and buffer. The property address is 15 Marshland Road with a parcel number of R510-008-000-013H quadruple O. The continuation of this public hearing is a result from the board having subpoenaed a staff member as a witness and certain documents from the staff. Before proceeding with that subpoena and questioning by the board, the chair would note for the record that the chair became concerned about the conflicts of interest by the town attorney and perhaps a question about conflict of interest of the staff attorney directing the staff as to whether or not to respond to questions from the board. So on April 27, 2021, the day after the public hearing on April 26, 2021, the chair sent an email to the mayor, mayor pro tem, and town council members requesting independent counsel for the Board of Zoning Appeals for the continuation of this hearing. It is my understanding that the town is not providing the board with independent counsel for the continuation of this hearing. So I wanted to note that for the record. Then we'll move on to the subpoena. The subpoena was issued by the chair and is dated May 14, 2021. The subpoena was directed to Ann Sarin. And I apologize, Ms. Sarin or Siren, if I'm not pronouncing your last name correctly. Senior planner of the town of Hilton Head Island. And the subpoena was for this hearing. And Ms. Sarin is supposed to bring the following documents or objects. Number 1, any and all written communications, parenthesis, including without limitation, email correspondence, close parenthesis, including any attachments from yourself or any town staff to Mr. Taiwan Scott and or his attorney relative to or associated with your correspondence to Mr. Scott of September 2, 2015. And number 2, any and all photographs in the possession of the town which show the food truck and adjacent screening fence located at 15 Marshland Road, Hilton Head Island, South Carolina. Are there any objections to that subpoena? Hearing none.
Yes, ma'am.
I'm sorry, who is objecting?
Lawyer, Ms. Pritchard.
Yes, sir. What is your objection?
Well, first, the state enabling and legislation doesn't give you the authority to subpoena documents. And second off, Supreme Court came out with a ruling since the last hearing. You can't consider anything other than the 4 issues on the variance test. That's just crystal clear. They said it over and over again. They said it in the last few weeks. It is what it is.
Well, Ms. Bush, are you going to advise us?
Good afternoon. Chair Bryson, as we discussed during the last hearing, the town's position was that we would comply with the subpoena request, but our position was anything other than here and now and the criteria that the board has to consider, that being the 4 conditions, were the only things relevant. We are cooperating with the board, but our position aligns with Mr. Pritchard, and also the case that I sent along, the venture engineering case, reiterates that exact direction to the board, that anything else is extraneous other than the condition of the property.
Well, the chair has considered the objection and the statement by the staff attorney. The board's rules of procedure provide that the board may subpoena witnesses, and in the case of contempt may certify such fact to the circuit court having jurisdiction over such matters. Is there an opinion that that rule has been made void by the case that was cited?
That is my opinion, Madam Chairman. The case was rendered on May the 12th, 2021, and it is pretty explicit that only the 4 criteria for variances are to be applied. And in that case, the circuit court had actually used some facts from a previous hearing, which the appeals court threw out because they didn't meet the 4-corner test.
Well, the chair, having heard the objections and having heard the basis for the objections, the September 2nd, 2015 letter having been introduced into evidence at the beginning of this public hearing on April 26, 2021, and admitted into the record without objection, the chair overrules these objections. And the witness, Ms. Anna, I'm so sorry for not pronouncing your last name correctly, but I understand the witness is available. The board has been furnished with 2 documents, the September 2nd, 2015 letter, and a letter in addition to that from Ms. Lewis, dated October, and I apologize, I don't have that, I have to pull it up on my screen, October 2015. The board will apply the 4 criteria as required by law, but the evidence would be used to apply to those 4 criteria. And the board will hear the evidence subpoenaed by it. So, Anne, I apologize. How do you pronounce your last name?
Yes, ma'am. It's pronounced Siren.
Siren, thank you. Thank you, ma'am. So, Ms. Siren, I understand you're available. And is there an objection to Ms. Siren testifying? Absent the previous objections.
Only if she's going to testify to the issues related to the 4 criteria and nothing else.
Okay. All right. So at this time, we have the witness available and we're to board questions. And I'm looking at my handy dandy list. We try to do a rotation of board members. Mr. Fingerhut, in this case, your name is first on the list.
Wonderful. Okay, thank you. Ms. Siren, are you here?
Yes, sir.
Okay. Thank you very much. I see you now. So I'd like to Um, since we're not together in person, it's more complicated, but I'd like to do a screen share so I could show Ms. Siren documents. Is that, I know how to do it, but I'm asking permission before I do it.
Ms. Haley, can you assist Mr. Fingerhut?
Certainly. Mr. Fingerhut, you may share your screen at any time.
Okay, thank you. I just didn't want to do it without specific permission. Okay, I'll be ready in a moment. Forgive the delay. Okay. I'm sorry, let's see. Okay, is everybody able to see a letter on their screens?
Ms.
Yes.
Fingerhut, I'm able to. Any board members not able to see that? Okay. Thank you, sir. Go ahead.
Excellent, thank you. Ms. Siren, draw your attention to the letter on your screen dated September 2nd, 2015. Do you recognize it?
Yes, sir.
Okay. What do you recognize it to be?
It's a letter that I sent to Mr. Scott regarding his development application or his minor development review application for the property in question.
Okay. Now, referring to page 2 of that of your letter, staying with I'm sorry, is this a true and accurate copy of your letter? And I'm
Yes, sir, it is.
It is. Okay. I don't recall whether this or anything was put in as exhibits last time, but just for the purposes of clarity, I'd like to have this marked as Board Exhibit 1.
Ask for what purpose is being introduced?
May I respond to that, Madam Chair?
Yes, sir.
It's for purposes of clarity. It was a document presented by your client during his testimony in support of his application for a particular purpose. In fact, he showed a highlighted version of it. It was the subject of lots of questioning. It just, again, for purposes of clarity, so there's a record of what we're all talking about. That's the purpose.
Mr. Fingerhut, you may proceed. That was offered into evidence. While it was not labeled as an exhibit, it was part of the record.
Okay, so then it does not need to be a board exhibit. That's fine. Turning to, let's see. Turning to page 2. No, I'm sorry, the bottom of page 1 initially and then the beginning of page 2. You state, though the building and fence enclosure would not have been permitted in the setback area if the building permit applications for these structures were submitted as a part of a commercial development instead of a residential accessory structures, the building and fence enclosure do not have to be removed to bring into site to full compliance with the LMO. They are legally non-conforming structures. So Ms. Siren, just for clarity, that's what you told him in this letter, a part of what you told Mr. Scott in this letter.
Yes, sir, that's what the letter states.
Okay. After this letter was written, were there other communications with Mr. Scott as to whether, in fact, these structures could remain as they currently exist?
Sir, I've been advised that I'm unable to discuss anything other than factual information about this letter.
Okay. Well, let's do this then. Let's go to the other letter that was produced pursuant to the subpoena. Hold on for a moment. I'm sorry. I generally know how to do screen share, but I'm not particularly good at it. Okay. Turning to the other letter that was produced pursuant to subpoena, written by Well, forgive me, I'd like you to identify it. It's up on the screen now. Do you recognize this letter?
Actually, sir, I don't. This was written, I believe, by Terry Lewis, and I didn't have knowledge of the letter.
You have no knowledge of this letter? It was produced pursuant to a subpoena served on you.
I think the letter you're referring to was written by Terry Lewis. I wasn't copied on the letter, and I have no memory of the letter.
Okay. Well, I guess in that case, I have to ask Ms. Lewis about this letter.
Mr. Finger, while we have this witness available for board questions, if we could stick with her. And then after that, Ms. Lewis, I understand, is available for questions.
Okay, excellent. So, Ms. Siren, just to be clear, is it correct? I don't want to put words in your mouth to say that you have been advised that you may only testify about your September 2nd letter. The September 2nd, 2015 letter. Is that correct?
Yes, sir.
Okay, so it's not necessarily that you don't remember something or you've been instructed not to do so.
I have been advised not to discuss anything beyond the letter. It's also factually accurate that I don't remember and wasn't involved, to my memory, with anything to do with this October 21st letter.
Okay. Were you ever at a meeting at 15 Marshland Road in the fall of 2015 with Mr. Scott, Ms. Lewis, other employees of the town, other individuals that you would recall? Not a casual meeting, a meeting at the site pertaining to the issues raised in your September 2nd letter. Do you recall any such meeting?
Sir, that would be beyond what I've been advised to discuss at this meeting.
Well, okay, thank you. Madam Chair, if the witness, and I frankly sympathize, if the witness has been advised not to answer any questions, even factual questions, then it's very difficult to continue to inquire for me.
Okay. So we'll move on to the next board member on my rotating list. Mr. Walczak, do you have questions of Ms. Siren?
Well, the only question I have, but I'm sure she won't be able to answer that either, is who told you not to answer on other questions other than this letter?
Sir, I received legal advice from my supervisors not to answer questions.
So it's my understanding, Mr. Walczak, that the witness is testifying she received legal advice from an attorney representing the town.
I'm here.
Okay.
That's correct.
Okay. Thank you.
Anything else, Mr. Walczak?
No, that does it. Thank you.
Ms. Loudermilk, it's your turn in rotation.
Okay, let me try one question that I believe is factual and directly party to the letter. Mr. Fingerhut was reading from the bottom of page 1 going into the very top of page 2 of that letter. And I will reread the last sentence that I believe he spoke to. Though the building and fence enclosure would not have been permitted in the setback area if the building permit applications for these structures were submitted as part of a commercial development instead of residential accessory structures, the building and fence enclosure do not have to be removed to bring the site into full compliance with the LMO. The next two sentences follow. They are legally non-conforming structures. The remaining non-conforming site features, however, must be brought into compliance with current LMO standards. to the maximum extent practicable. What are the remaining non-conforming site features?
Ma'am, I want to be helpful to you, but I've been advised not to give any information other than basic information about the letter, the fact that I wrote it, the fact of when it was sent. I don't think I can answer your question.
Even though we're asking for factual information.
I was asked.
Yep, no further questions.
Okay, thank you, ma'am. Dr. Ponder, it's your turn in this rotation.
I have no questions at this time.
Thank you, ma'am. Mr. White, any questions of you?
Yeah, I was going the same place. So if it's just a clarification of what you wrote, you are not allowed to speak on that?
Sir, I was only asked to confirm that I wrote the letter, the date was sent, basic information about the letter.
Okay. Thank you, Madam Chair. That's all I have.
Yes, sir. So it's to the chair now for questions, unless did I miss any board members in the rotation? Thank you.
Yes, this is Bob Johnson.
I'm sorry, Mr. Johnson.
It's all right. I have no questions at this time.
Okay, all right. I apologize, Mr. Johnson. So Ms. Siren, questions from the chair at this point. Did you correspond subsequently with Mr. Scott? That's a factual question.
Ms. Bryson, I want to be helpful. Like I said, I was only asked to verify that I sent the letter and the date that I sent it.
Okay, do you have a copy of the subpoena in front of you?
Yes, I do.
It says any and all written communications, including without limitation email correspondence, including any attachments from yourself or any town staff to Mr. Taiwan Scott and or his attorney relative to or associated with your correspondence to Mr. Scott September 2, 2015. I will ask you one more time. Did you send any other correspondence to Mr. Scott after your letter of September 2, 2015?
Ms. Bryson, I was asked just to speak about the letter that was included in the packet, and any other questions I'd prefer to defer to Diane Bush, who's the town attorney.
Ms. Bush, can she respond to my factual question whether or not there's any other correspondence sent by her to Mr. Scott after September 2, 2015?
Not that I'm aware of from Ms. Siren.
Okay. So your response is there was no other communication from her, not that she cannot respond.
What you have in front of you is in compliance with the subpoena.
Okay. Any other board members have questions of Ms. Siren?
I have a question of Ms. Bush, if that's okay.
Yes, sir.
I'm not a lawyer, I'm an engineer. Okay, so I kind of tend to think practically. But what I'd really like to know, and I know this might be, I don't know, controversial in what I'm about to say, but aren't we in the town all on the same team trying to reach a conclusion here? It seems to me like, one part of the town is fighting another part of the town here, meaning, our witness is refusing to talk about what we want to know at the advice of the town, but yet we are the town. I just find it disconcerting. So can you explain what's going on?
Yes, sir. We all are part of the same town. We don't want to be adversarial. However, this case was appealed to the 14th Circuit, and as a result of that, a mediation agreement was reached. Part and parcel of the mediation agreement was that Mr. Scott could appeal to this board, but that the town would stay out of it. Or rather, that's what we interpreted. that because we're under a mediation agreement, that the authorities coming from the 14th Circuit who approved the agreement, that the town staff could not have any involvement. It had to be between Mr. Scott and the board and the 4 criteria. And so part of what's converging is not only the confidentiality of the mediation agreement, in that town staff stay out of it, but also that what we've been repeatedly told, and most recently on May 12th, in an opinion that was just published on the 12th, heard on in February, that the only thing the board can consider are those 5 or 4 conditions. Everything else is out. So for those combined reasons, we're asking the board to stick to the 4 criteria and to help us not get in the way of this mediation agreement. Or help us is perhaps not the right word, but that is what we're trying to do. We're not trying to be adversarial or coy. We are trying to follow an order. Does that make sense?
Yeah, well, okay, but so how will this ever end?
With your decision.
Well, yeah,
Well,
I
Mr.
knew that
Scott,
answer, but practically how it will end, I don't know. Okay.
I
Thank
don't
you
know
for-
the answer to that one.
I know. Thanks for the explanation, though. I appreciate it.
Yes, sir.
This is Lisa Laudermilk.
Yes, ma'am. Go ahead.
I have a question. I'm really not sure to whom it should be directed.
It's directed to the chair, and I'll try to redirect.
Thank you very much. If we are to be focusing our consideration, not just decision, but our consideration solely on the 4 criteria, is it fair to say then that we should not be evaluating, using, reading, we should not be considering the outside correspondence that was introduced by Mr. Scott? I mean, is it fair to say that that is a superfluous document not related to the 4 criteria?
That would be my opinion. And I would suggest to you there's lots of factual information available on the application that has been filed in the variance that about which questions can be asked.
And I understand that is Mr. Michael, who represents the town's interest, but not the board's interest.
Correct.
That would also be my
Sorry,
interpretation.
Mr. Pritchard, okay. Thank you. I thought I heard you speak. Okay.
And that would be my position as well, Chair Bryson.
Okay.
That nothing matters other than here and now and those conditions.
Madam
And that's
Chair,
what
may I
the
ask a
court
question?
Yes, sir. I think, was that Mr. Fingerhut?
Yes.
Sir.
Thank you. First of all, I completely agree with all 3 counsel in this, that it is the 4 conditions that are the only thing that's important here. The letter that set all this off, of course, was introduced by the applicant, not by anybody on this board. And that letter gave a certain impression of a change of position that I'm not certain is accurate. But that's what started this. But my question is this. Since it's the 4 criterion that are important, one of those criterion is whether or not there's another way to do this. There's another way to give the applicant what he wants without granting this variance or with granting a different type of variance. And on that basis, the October 21st, 2015 letter is squarely on point, very germane, and has been in the public domain since at least January 25th, 2016, when it was in a court file, when it was in a hearing file for the Board of Zoning Appeals. And it's, of course, been in the town's records for all of that time. And so you produced that pursuant to subpoena. So we're no daylight here. I agree completely. I think it's relevant. Here's my question. The letter has an attachment that was not supplied. And I guess what I'm asking is was that an oversight or was that intentional?
And I guess, Ms. Bush, that's to you. I think you accepted service. You helped serve and you accepted service and you produced the document. So.
Yes, ma'am, I did. I wasn't aware that there was an attachment, so it was an oversight. I don't know what it is. Haven't had a chance to review it.
It's referred to in the letter. I'll have to find exactly which paragraph, but
first sentence of the second paragraph.
Thank you, sir.
You're welcome.
I see it now.
And so I would suggest that the compliance with the subpoena is somewhat incomplete since it refers prominently to an attachment. It is germane to part of our evaluation, and yet it's being, at best, not provided. I won't use the term withheld, but at best not provided. Now, of course, it is publicly available and will be ultimately a part of this record, but I'm asking if the town has it, can you please just produce it and not ask us as board members to produce things? I would be my preference.
I can assure you it was not purposefully
Certainly
withheld. And I have to go back to I don't necessarily agree with you, Mr. Fingerhut, that these things are relevant because there could be an alternative. That was 2016. And things change. This is 2021, and that's 5 years ago. Any kind of relevance that plan or alternative may or may not have would, if that's what you're considering, it would seem that it would have to be revisited.
Well, I mean, what was it? I believe in 2016, one of the conditions was to apply the ordinance. This particular piece of property would effectively prohibit or unreasonably restrict its use. That was then a condition, and it is today a condition. And that's why I suspect that's why you produced this letter. It's helpful, but I'm only seeing half of the story. We all are. Excuse me. That's not just me. So,
if you read the May 12th case that was just recently handed down, the Board of Appeals, like you, and the Circuit Court both had applied facts that were involved in a 2007 application, which the Court of Appeals totally threw out because they didn't meet the factual situation of the variance that was applied for on the later date. So the same thing is applicable here.
Mr. Michael, with all due respect, we are applying the 4 criteria. What the board is asking for is factual information so that we can make a decision. We can determine whether or not something is relevant or not, but unless until we see the facts, then we can't make a determination, and that is our challenge.
But you're not asking questions about what's out there on the site today with regard to the documents that are been submitted with the variance. You keep asking questions about what happened in 2015. So you're not applying today's factual information.
Well,
there is a drawing here, and there's an explanation of the drawing. I haven't heard one question about that document.
Well, we're trying to get that document. With all due respect, sir, during the April 26th hearing, the board asked questions about what is on the site today, and the applicant produced the September 2015 letter, and the board asked more questions about that. And the board was stalemated, and the board issued a subpoena so that we could see the documents and ask questions about what is on the site today.
Well, my response would be that Mr. Scott, and I'm not trying to stick up for him, but he was in error about doing that in the same manner that I think perhaps you guys are being in error today. So let's wipe the slate clean and start over again with factual information about what's on the site today.
And might I interject?
Yes, sir.
This is an unfortunate hazard of a Zoom meeting, because had we been there together live, it would have never shown up.
Well, the board is stuck with what we're stuck with, and we are doing the best that we can. I'm going to ask the board to proceed and decide who they want to believe. I think that the next
believe. I mean, I'm sure it's about the facts on the ground. I mean, there's no believe to it. I mean, it's a question. Frankly, I must say, Mr. Fingerhut, I don't necessarily agree with your interpretation of the statute of is there another alternative. That has never come into the law. Never seen it. In fact, I've seen some hints that might not be correct. The question is it unreasonably restrict? I think that's the question and the question alone.
Okay. Any other questions of the last witness we had, Ms. Siren, who's patiently waiting on us? Okay. I think, Mr. Fingerhut, you wanted to ask Ms. Lewis some questions, and I understand Ms. Lewis is still available. Ms. Lewis, are you still available?
Madam Chair, this is Ms. Haley. Ms. Lewis is available.
Okay. Let's go ahead and proceed in the same order that we did before. Actually, I'll do a rotation. I'll start this time with Mr. Walczak.
Well, let me ask her this. This is the only thing that's on my mind now. Of that letter that was presented, do you know, in fact, that the information contained in that letter is, in fact, accurate? Or was some of that information perhaps in error?
And which letter are we talking about?
The 2015 letter that was presented by the applicant?
Mr. Walczak, are you talking about the September 2nd, 2015 letter sent by Ms. Siren?
Yes.
Thank you, sir. Ms. Lewis?
I don't believe I can answer that question because I was not the author of that letter.
Okay. Is the
I'm here to
author still,
respond.
is the author still there?
Ms. Siren, are you still here?
Yes, ma'am.
There she is.
All right, the question was, if it's okay, the information provided in that letter, since you can answer about the letter, was it in fact accurate? Or was it perhaps certain things were said in that letter that might have been in error?
Sir, again, I want to be helpful. I was asked only to answer basic facts about the letter. The fact that I sent it the date that it was sent. And any other questions, I'd prefer to defer to Diane Bush.
But you wrote the letter. Was it accurate, or was there an error in it? We're asking about the letter.
Sir, I've been advised just to answer factual questions about the letter and to defer any other questions to Ms. Bush.
Yes, sir. With all due respect, that's correct. Staff has been directed to verify whether or not they signed something, the date, but the facts, and back to that. The focus should be on what the property looks like today and whether or not it meets the 4 conditions.
Thank you.
Okay. Mr. Walczak, do you want to go back to Ms. Lewis for questions or any more from Ms. Siren?
No, that's all. Thank you.
Okay. All right. Ms. Lewis, I see y'all are playing musical chairs there. If we'll wait on you to come back. Okay. Thank you, ma'am. Ms. Loudermilk, do you have questions of Ms. Lewis? Ms. Loudermilk, I think you're muted. There we go.
I do have a clarification question relative to the letter, if in fact it can be answered.
Okay, give it a shot.
Yeah. The third paragraph of the October 21st, 2015 letter starts with a sentence. The second option is to do the first option and apply for a variance, asking for a 15-foot adjacent use setback instead of the required 30-foot setback. That nowhere does it go on to discuss a buffer. So my question is, reducing the setback by 15 feet, is that eliminating the buffer totally?
So just as Ann said, I'd like to be helpful, but again, I've been advised to speak to the fact that the letter was sent. I sent it, I signed it, and that's what I can speak to.
That is correct. That is the advice that I have given them.
Okay, thank you.
Thank you.
Anything else, Ms. Loudermilk?
No, thanks.
Dr. Ponder, any questions for Ms. Lewis from you?
No, not at this time. Thank you.
Mr. White, any questions from you of Ms. Lewis? Mr. White, you might be muted. I see you're with us, but we can't hear you. I'm sorry.
Can you hear me?
Yes, sir.
I said there were a couple of questions on the October 21st letter, but apparently I'm not going to get, or we aren't going to get any answers to clarify the point. So I will pass my time on to someone else.
Okay. Thank you, sir. Mr. Johnson, any questions from you?
I have no questions at this time.
Pardon me. Mr. Fingerhut, any questions from you?
Just a couple. Ms. Lewis, looking at the October 21st, 2015 letter that you supplied in response to the subpoena that was served, did that letter have an attachment?
I can just state that the letter states that it says, I will circulate the attached site plan.
You mean where it says see attached site plan? Is that where the place you're referring to in the second paragraph?
Yes, sir.
Okay. Do you have a copy of that site plan?
I can only say right now that, what I sent was this letter.
Okay. So basically what you're telling us, and I understand and sympathize that you're telling us that you, and actually Ms. Siren did the same thing, that you are giving what I would refer to as envelope information only. Yes, this is my signature, that's my letter, and I can't say anything else about it other than that's it. Would that be correct?
That's the advice that we have been given, yes.
Okay. If I were to show you the attachment, since it is in the public domain, would you identify it for me?
I would have to defer to Diane Bush on that question.
Okay.
We can ask Ms. Bush if she needs to respond.
Do either of the other attorneys want to weigh in on this before?
At this point, we're trying to figure out if we even have an attachment. I've never seen an attachment if there was one.
I mean, I could speak to that if that's a real question. If you're asking, I can speak to that, but I wouldn't respond to a question
I'm not
without the
asking,
chair's
just telling you
consent.
that if there is one, I've never seen it. It was not provided to me ever.
I think if you ask her about the authenticity of a document that's a public record, she can answer that.
I would tend to agree, but I'm thinking that that's not what's going to happen here. I mean, you're witnessing this in real time like me. I don't want to ask Ms. Lewis something that she's been instructed not to do. She's doing what she's been told. On the other hand, I would agree with you.
But you're not asking her if it is an attachment to that letter. If you ask her if it is a matter of public record, I think that is a question she can answer.
Thank you, counsel. I appreciate that. Ms. Lewis, is your September 21st, 2015 letter?
No, now you're going back to the letter.
Well, then I guess I just don't understand the help I'm getting. I'm sorry, I just don't understand that. Referring to your reference to an attachment, are you aware of whether or not it's a public record?
I'm going to defer to Diane Bush on that question.
Mr. Fingerhut, I was not aware of the attachment. The letter that you're referring to of October 21st was made public along with the packet, the BZA packet at the time, back in 2015. Whether or not that attachment is filed, I can't say.
Okay, Madam Chair, may I use screen share? Yes.
If there was an attachment, it'd be fair to assume that it was published as well, but I don't know the answer to that information. I wasn't here in 2015.
Mr. Fingerhut, I think you wanted a screen share. I think the first question before that is, Ms. Bush, is the October, I apologize for not remembering the date, the October 21, 2015 letter a matter of public record?
Yes, ma'am.
Okay. Now, Mr. Fingerhut wants to screen share. Ms. Haley, can you assist with that?
I think I could do it.
Okay.
Madam Chair, thank you.
Yes, sir.
Okay. Could everybody see my screen?
Yes, sir. I see the October 21, 2015 letter.
Okay.
It was produced by subpoena.
If you look at the, this is from the town's website as we speak now. If you look in the address bar, Hilton Head Island, southcarolina.gov/board/agenda/2016 packet/BZA-1-25-2016-pack.pdf. And this letter appears as page 138 of that record. There's many other things here, but I did not want to offer to clutter the record, excuse me. And so I'm just going to this letter since the letter was produced by the town. And if we scroll slowly, page 138 to page 139, and then page 140, there it is. So there is the attachment that the letter describes, that I will note uses the same site plan that everybody else is pointing to here, but it has markings on it that make it particularly useful to the type of analysis this board does. So I would like to ask Ms. Lewis, who I believe is seeing this now, is this the attachment to your letter?
And Terry, you can answer that.
Okay, I was going to ask if I could answer that. Yes, this is the attachment to that letter.
Thank you very much. And if I ask for some explanation, am I going to get, is that going to be permitted, or are we going to make the attachment speak for itself?
Yes, sir. I'm afraid that's the exact words.
Nope, that's fine. I'm perfectly content for that. I would like to offer this page 140 out of 342 out of the town's public record as Board Exhibit 1.
As an attachment to the October 21, 2015 letter from Ms. Lewis to Mr. Taiwan Scott. Is that correct?
Yes, it's page, it comes right after the letter. It's page 140 out of 342 in the town's record of the BZA meeting of 1/25/2016.
Okay. Any objection?
Yes, very much so.
That's Mr. Pritchard.
First off, this is a 2015 document. This is a 2021 zoning variance. Who's to say any of this is relevant at this point in time? It has nothing to do with this variance application. It's not for town staff to go out there and redraw it and redraw the application. And I'm sorry, but the test that is apparently being applied here is not legally correct. Thank you.
Any other objections? Well, the chair is going to allow the document to come into the record, and the board can determine the relevance during its deliberation.
Thank you, Madam Chair.
Go ahead, Mr. Fingerhut.
Well, actually, since the letter with its attachment are going to need to speak for themselves, I won't ask Ms. Lewis any further questions because as I understand it, she can't answer.
Okay.
I've been instructed not to.
Yes, thank you, sir.
Thank you.
Let me make sure, is there any board member that cannot see this exhibit?
I was just going to ask, this is Lisa Laudermilk,
Yes, ma'am.
if the exhibit can be enlarged.
Mr. Fingerhut, are you able to do that?
As we speak.
Thank you.
Sure, pleasure.
Thank you.
Can you now see that, Ms. Loudermilk?
Yes, I was trying to read the handwritten.
Okay. We'll give the board members just a minute. Any other board member with any challenges in reviewing this document? Anybody else need any more time with the document? Otherwise, we'll move on. Okay, thank you, sir. I guess we can stop the screen sharing unless any board member wants to.
Yeah, Madam Chair.
Yes, sir.
Would it be appropriate to just comment on this drawing?
Yes, sir. I'm sorry. Is that Mr. Walczak?
Yes, it is. I'm sorry. Yes.
That's okay. And so, Mr. Walczak, you want to ask somebody some questions?
No, I'd just like to make a comment that from what I see in this drawing, and by the way, this whole letter and drawing was submitted, yes, 5 years ago, but it was submitted as part of this application for the variance today. So this thing about years gone by. The thing I noted here, if you look, someone drew on their food truck kind of in the center of the property, as opposed to where it stands now. I just want to point that out. I presume that was drawn by the town on there. I'm not sure, but I just thought I'd make that comment.
Okay, thank you, sir. Anything else from any board member before we move from the screen sharing to any more questions by the board members? Okay, Mr. Fingerhut, I guess if I can ask you to stop the screen sharing so we can move on. All right.
Thank you.
Any other questions, Mr. Fingerhut, of Ms. Lewis?
No, thank you very much.
Okay, all right. So that will be to the chair. The chair has no questions for this witness. We are at the point, I'm sorry, did I hear someone say something? Nope, okay. It's a challenge to try to make sure that I include everyone who wants to speak, and sometimes not being able to see who's speaking or being able to identify them. So forgive me if I keep asking if anyone's saying anything. All righty. Oh, Ms. Bush.
I just want to correct something for the record that the matters in 2015 did not involve any application for a variance.
Okay. All right. Okay. So I think that concludes the matters of the board subpoena. Any other questions of folks who are present by board members before we incorporate all the evidence and well, let me give the applicant a chance for any rebuttal. Okay, hearing no other questions from board members at this point, I will offer an opportunity for the applicant to have rebuttal. Generally, Ms. Haley, help me, don't we usually allow 5 minutes for rebuttal?
Yes, ma'am, that's correct.
And Mr. Pritchard, we will try to be considerate of the time based upon the time it took for questioning by the board members. So you can have up to 5 minutes. Ms. Haley will be our timekeeper. She'll give you a gentle reminder, and then the chair will determine whether or not you can extend that time period.
Well, I think we've got adequate information before you with regard to plaques and the other things that have been presented, that there are extraordinary and exceptional conditions pertaining to this particular piece of property. I don't think there's any real argument there. And I don't think there's any argument that they don't generally apply to other properties in the vicinity. Where I am getting concerned is I'm listening to some of the comment, having done this myself for about 3 decades now. The question is not whether or not you could physically fit something on the property in another form or fashion. The question is whether or not—
Mr. Pritchard?
Yes, ma'am?
Excuse me, pardon the interruption. This is Miss Teresa Haley, the secretary for the board. I do see that Miss Bryson, our chair, has dropped off the meeting, and she is rejoined. So I wanted to pause the meeting to give her a chance to come back on.
I appreciate your doing that. Is she back?
Miss Bryson?
Here we go. Am I back on now? I think
Yes,
I
ma'am.
need— Oh, hang on. Here I am. I apologize. Don't know what happened to that connection, but here I am back again. Sorry, Mr. Pritchard.
But what the test really is whether or not these conditions of the ordinance, the application of the ordinance to the particular piece of property would effectively prohibit or, and here are the key words, unreasonably restrict the utilization of the property. Given what its permitted use is, and given what Mr. Scott's intended use for the property is, basically to run an open air market with tents, not a lot of structures, placing that truck in the smack dab middle of it is going to completely obliterate a permitted use. It's not going to work, and it needs some continuity. And frankly, it's pretty clear that not granting this variance is going to unreasonably restrict the utilization of this property as is otherwise permitted by the ordinance. I just don't think there's any question about that. And we just keep getting off track, and that's the point, is the unreasonably restrict, and it does. There's no question about it. And so therefore, I just don't think there's any question that this has been met. The authorization of the variance will not be a substantial detriment to the adjacent property or the public good, and the character of the zoning district where the property is located will not be harmed by the granting of the variance. We've seen no evidence that would happen. I mean, I think it's pretty clear that it's not going to be any substantial detriment. It's in character with the neighborhood. It fits within the neighborhood. It's a permitted use, and I think this is a classic reason for this variance test. I think this is why it exists. I think it's why we have this process and we go through it. And I think in this instance, I just don't see how it can be denied. I mean, if you look at your test and you look at the state law and the interpretation of the test, I just don't see how you can deny it. But anyway, that's all I got to say.
Okay. Thank you, sir. Any board discussion after the rebuttal? Hearing none, I'll move on to opportunity for public comment. Ms. Haley, can you tell us whether or not there were any callers who wanted to comment during this continuation of the public hearing?
Madam Chair, there were no callers regarding this variance.
Thank you, ma'am. At this time, I'll incorporate again all the evidence heard at the initiation of this public hearing on April 26, 2021, and the continuation of this hearing on May 24, 2021, subject to the objections made of record. Anything else to be entered into the record at this point? Any other objections? Hearing none, I will now close this public hearing and we'll move on to board discussion.
Chair Bryson, but before y'all go
Sorry.
into your, I'm sorry, Diane Bush here, if
Yes,
I may.
ma'am.
As
Yes, ma'am.
counsel to the board, and before you go into discussions, given that we've spent a lot of time talking about 2015, I wanted to reiterate to the board that this very, very recent case, Venture Engineering versus Horry County Zoning Board of Appeals, very specifically tosses out anything that is not pertinent to the condition, the four conditions. So I respect that the being left in a position without staff recommendations or a report that this board wanted to look back. My cautionary recommendation is, as you go through your discussion, just keep this case in mind. Everything that was considered prior to the current undertaking in the Venture case was tossed out. It just wasn't relevant.
Anything else, Ms. Bush?
No, ma'am. Thank you so much for the time.
Okay, all right. So we'll move on to board discussion. And I want to make sure as we have this discussion, and after discussion, then I'll ask for a motion. Does any board member not have the variance motion template? Because at this point, we'll have to produce our own motion. Any board member need the variance motion template? Hearing none, I'm assuming that everyone has one. So let's move on to board discussion. And I have a rotation order here, and I apologize if you feel like I call on you first every time. I'm trying to look down my handy dandy rotation order. This time, Ms. Loudermilk, your name is first on my rotation list.
Okay. I think one of the things I am struggling with here, and again, it's one of these questions that I'm not sure who it's directed to or if there's really an answer. The criteria 3, focusing very specifically on the criteria about the application of the ordinance effectively prohibiting or unreasonably restricting the utilization of the property. I think about the capacity, the amount of utilization. And again, in this specific instance, you know, clearly one food truck will fit on this property. I'm certain one food truck and 2 vendors may fit on this property. Will one food truck and 30 vendors fit on this property? And the answer is probably not. So I struggle with the definition of the unreasonably restricting the utilization of the property. That's the criteria that I'm really, again, trying to weigh. What is unreasonably restrict? I mean, any site, I don't care what the usage is. You know, if I have an eighth of an acre residential property, I'm sure I can build a, 800 square foot home. Can I build a 5,000 square foot home? No. So there's a capacity issue here, and I don't know where the threshold is. I'd like to hear other thoughts about, when does unreasonably restrict start to come into play? That's the consideration I'm really struggling with.
Okay. Thank you, ma'am. Dr. Ponder, discussion from you.
Sorry, I was having a bit of trouble getting the mute off.
Sure.
I don't think that my position on this case has changed since the last time we discussed it. And I tend to think that we should grant the variance. I hear you, Ms. Laudermilk, and I actually really like your question about, the restrictions. I don't think that the number necessarily matters as much as the ability for intended use, right? Because you could have this dream, I'm gonna have a 5,000 square foot house on this little parcel of land. And then when you get to it, you realize, you know what, I'm only going to get 3,200 square feet on this land, right? But you're still being able to use the land for what you intended, which was the house itself, right? And so the number of vendors on the property isn't so much my concern. I mean, that to me will be worked out and probably not by us. I think that the criteria are met here, and I would tend to say we grant the variance.
Just for clarification, this is Lisa again.
Yes, ma'am.
I'm not really focused on the number, but again, it's like you can only do 3,200 square feet versus 5,000. There is a concept of reasonable. What is reasonable to expect to, utilize this property for? That's kind of what I'm struggling with. Where do we get reasonable and unreasonable?
I think
it's not the number.
Right. I hear you. And I think we're struggling with a lot of definitions in this particular case. And so at some point, I think the definition of reasonable becomes what we're going to make it, in a sense, right? We're not going to get the answers to the questions that we wanted to ask, right? We're just not going to get them. And we have to accept that, use our best judgment within the criteria as laid out by the LMO and the instructions that were given with these 4 criteria, and make the best decision that we can make based on what we know. And I just think it is, to some extent, that's what we're dealing with here, that our questions are not going to be answered. And the semantics of reasonable, I hear you. And I agree, and I would love to have the answer to that question too, but I also understand that we're not going to get it, as much as we're not going to get the answers to a lot of the questions here. So I'm going on what I know, and from what I know about this case, and from the presentations that have been made from all sides, I tend to think we grant the variance.
Okay, thank you, ma'am. Mr. White, discussion from you.
I'm tending to go to the same area, and that is with number 3. I do think the capacity issue is an interesting one, and I think it's probably a self-controlled situation, because you can put as many as you want in there, but you're still going to have parking in a limited space. So that, to me, is the regulator to capacity. And I tend to agree that this probably should be approved.
Okay, thank you, sir. Mr. Johnson, discussion from you.
Well, yes. Fellow board members, what are the extraordinary and exceptional conditions pertaining to this particular piece of property? Is it the road that goes to the lots in the back? Is it the size of the property? I don't see either one of those being exceptional or extraordinary. These conditions do generally apply to other properties in the vicinity. I would guess if it's in the LMO, it would be applied to all the adjacent properties and up and down the street. It says here, this piece of property would not effectively prohibit or unreasonably restrict utilization of the property. I think if we were to disapprove it, it wouldn't prohibit or unreasonably restrict utilization of the property. It still could be utilized. It's just the configuration of the items on the property. The authorization will be of substantial detriment to adjacent property or the public good. It doesn't say, it says either or. As I would take it, the adjacent property is subject to the infringements on the
Anything else, Mr. Johnson?
No.
Okay. Thank you, sir. Mr. Fingerhut, discussion from you.
Thank you, Madam Chair. I also question the extraordinary and exceptional conditions category, but for me, I would say sure, maybe. You know, there's wetlands, there are setbacks to that, there's an easement, so saying yes to that, I think would for me would be fine. My problem begins, I would say, at the second category, and that is that these conditions do not generally apply to other properties in the vicinity. This property is located on Marshland Road, the historic neighborhood known as Marshland. It's marshy there. There's water on people's property, and in fact, on at least one of the exhibits submitted by the applicant, and it's his site plan, which is in a couple of times. It's in once clean, and the other time as an attachment to Ms. Lewis's letter. It's the same document, and that's the applicant's site plan. It shows water on his neighbor's property. So, you know, I don't see how, as a fact-finding body, we could find that this doesn't apply to other areas, because it has not been proven. And in fact, I would suggest it has not even attempted to be proven. I've heard statements from counsel who frankly has no firsthand knowledge of this, so that can't be considered. I've heard no statements from the applicant as to that condition specifically, as to whether the conditions don't apply to others. And the applicant has the burden of proof. So I would suggest on 2 that it's not proven. Now, as to the application of the ordinance to this particular piece of property would not effectively prohibit and reasonably restrict use of the property, that's where Ms. Lewis's letter of October 21st, 2015, from an earlier BZA matter pertaining to this property is so helpful because it gives us the type of insight we normally get from the town that we're being denied, unfortunately, for this hearing. And I questioned the applicant directly on this when we were at our April 26th hearing. There is another way that it could go. In fact, there's a couple of ways that it could go. One that would require a minor variance, and the other that would require no variance at all. And again, when I questioned the applicant on this, because I was aware of this letter, so I was questioning closely on this, and when I asked whether he would consider moving it, the applicant said, and everybody's welcome to look at the recording, why should I? Because he felt that the September 2nd letter gave him permission to have it there. That's the point, and that's why I feel that I felt that was so relevant, and that's why it's raised. So, as to the question of when these facts occurred, they occur now because the applicants told us they occur now. Nothing's been moved here. The site plan was submitted by the applicant. Everything is the same as it was in 2015. This structure's been there for a long time, 6 years at least. It's been there, and we're only hearing a variance application now. So that's the third category. And then as to the fourth, I mean, I agree with Mr. Johnson. It's in very close proximity to a residential property. I mean, within 3 or 4 feet to the property line. And you know, whether there have been complaints or not, you know, the LMO promotes, you know, space and natural landscaping and buffers and light and air. And it's just, to me, it is the antithesis of what the LMO is trying to accomplish. So that's my take on each of the categories. I could say it more specifically with findings of fact and conclusions of law, but I just, as much as I sympathize, I just don't see how we could grant this application and apply the law as written. Thank you.
Okay, thank you, sir. Mr. Walczak, to you.
Yes, I tend to agree with Lisa and with David in that I don't see why the truck, since it's movable, it's not a, you know, fixed object, why it couldn't be repositioned to get it out of the buffer and reconfigure the property so that it does function. I just don't see that. So that's about all I have. Thank you.
Okay, thank you, sir. So now it's to the chair in discussion. Having looked at the site plan that was submitted on April 26, which purported to tell us the conditions as of today, being the continuation of the hearing, and not considering the documents from 2015, I do believe that there are conditions that apply only to this property, while there are marshy areas along that area as shown on that site plan. There appear to be more wetland intrusions, a narrower lot, easements across the property that do reduce the amount of property available for this particular lot compared to the adjacent properties as shown only on that site plan and as shown by the aerial photo, which was a part of this hearing, and not any documents from 2015. In addition, there's some confusion about the adjacent use setback and the adjacent use buffer. And there's also a street setback. So all of those also add to the restricted amount of property available for use on this particular lot. And because, based on the testimony that we've heard at this hearing from the applicant, and not anything from the 2015 letters, those structures have been there for some time. So applying those criteria to the facts that we are able to consider at this hearing, I do believe there are extraordinary and exceptional conditions pertaining to the particular piece of property, being those items that I just listed. Secondly, The second criteria, these conditions do not generally apply to other properties in the vicinity. The only evidence that we have, pro or con on that condition, is the site plan, the aerial, the photographs submitted by the applicant, and the testimony of the applicant. So I believe those conditions do not generally apply to other properties in the vicinity. As to the third condition, the application would effectively prohibit or unreasonably restrict, the application of this ordinance, meaning the LMO itself, the entire LMO, to the particular piece of property would effectively prohibit or unreasonably restrict the utilization of the property for those same reasons, because of all those various requirements. I do believe that it does prohibit or unreasonably restrict, because I think restrict is the key word there. The others are adverbial descriptions of that word. I do believe that that applies. As to the fourth condition, sorry, we're getting some feedback. I'll wait on that. As to the fourth condition, the authorization will not be of substantial detriment to adjacent property or the public good, and the character of the zoning district where the property is located will not be harmed by the granting of the variance. The structures have been there for some time. We do not have any public comment which complains about the fence and the food truck, which are the subject of the variance request, nothing else. We do not have any complaints about them, no public comment about them. And despite the fact that this matter has gone on some time, one would expect that if there were some sort of detriment to adjacent property for the public good, we would have heard that testimony, and we have not. So based upon those four criteria and the facts available to us as of the condition of the property during this hearing in 2021, I would be in favor of granting that limited variance as described in the application for existing non-permitted food truck and associated screening fence to remain in the required adjacent setback and buffer, notwithstanding that I do believe that we have setbacks and buffers for very serious reasons in our land management ordinance. And generally, I think we need to consider carefully whether or not we grant variances in the setback or the buffer. And only exceptional circumstances would lead to the granting of a variance in those areas. I believe in this case, based upon these very limited circumstances, that it would be appropriate. Any other discussion by board members at this time? If not, I would ask for a motion on the variance application. And our choices are to approve the application based on findings of fact and conclusions of law, which we must prepare because there is no staff recommendation, or approve the application subject to conditions of approval, or to deny, or to remand to staff due to an insufficient record, which may not be an appropriate consideration. I'll leave that to the board, or disapprove the application based on findings of fact and conclusions of law, which the board must determine since there is no staff recommendation. So I would ask if there's a motion, and if a board member needs time to scribble out a motion, we'll take a brief recess to allow for that. But I would remind the board that any discussion must be in the public about a motion because it's a public meeting subject to FOIA requirements. So is there a motion?
Madam Chair, could you repeat what we have to do for the motion? I'm happy to make the motion. I just want to make sure that I have your instructions on how to make this motion correct, to be perfectly honest.
Yes, ma'am. Yes, ma'am. So do you have the variance motion template available?
Hold on, I'm going to split my screen so that I can view it at the same time as I'm viewing this, our meeting.
Yes, ma'am.
All right, I've got them both.
Okay. So I was kind of going down that list. So if you want to approve the application, then you'll need to list some findings of fact and conclusions of law. And you would have to list those yourself. You can scribble them out before you make a motion. If you want to do that, we can take a recess to allow you time to do that. Second choice would be to approve it subject to conditions, and you'd also have to have the same findings and conclusions of law. The third would be to remand to staff due to insufficient record, which I was suggesting I'm not sure it would be of any more help in this case. And then the fourth option is to disapprove based on findings of fact and conclusions of law, again, which we must list because we don't have a staff recommendation. Does that help, Dr. Ponder?
It does help.
Okay.
Let's just see whether or not I can do it.
Yes, ma'am. And Ms. Haley, if you can assist, because we are making this from whole cloth. If Ms. Haley has any questions about the wording, and then we may need to repeat the motion so all board members understand it, since we don't have everything in writing. Go ahead, Dr. Ponder.
All right, I'm going to take a shot at this. I move that the Board of Zoning Appeals approve the application based on those finding of facts and conclusions of law, such as for criterion number one, extraordinary and exceptional conditions pertaining to the particular piece of property. I would say that the nature of the piece of property itself, particularly with regard to the wetlands, excludes it from generality because it is very particular, and the nature of wetlands themselves are in fact very particular, not general. And therefore, I think that there are exceptional and extraordinary conditions pertaining to this particular piece of property. For criterion number two, because of the particular nature of wetlands themselves and the way that this area of the island is sort of plays out, these conditions do not generally apply. They are in fact not general, they are particular. So they don't generally apply to other properties in the vicinity. Even though there may be wetlands, it is very particular. That is how wetlands operate. With regard to criterion number three, the particular nature of this property and the way that it is configured would, in fact, restrict the utilization of the property. I think we've seen that very clearly. With regard to criterion number four, I don't think that there has not been any proof that the granting of this variance would be of substantial detriment to any adjacent property or to the public good. Therefore, I move that we grant this variance based on the four criteria as presented.
And so that's your conclusion of law, that the variance be granted?
Yes.
Is there a second to the motion?
I will second.
Second by Ms. Loudermilk. Any discussion on the motion? Hearing no discussion, Ms. Haley, will you call the roll on the vote for the motion?
Yes, Madam Chair. Mr. Walczak?
As much as I'd like to see Mr. Scott succeed and prosper on with his venture, I'm concerned about the fact that we have a situation where the food truck can be moved out of the buffer, and that's one of the things that's bothering me. So I have to Vote against the motion.
Mr. White,
For the motion.
Miss Loudermilk,
For the motion.
Mr. Johnson,
Against the motion.
Mr. Fingerhut,
Against the motion.
Dr. Ponder,
For the motion.
Miss Bryson.
For the motion.
Motion carries 4-3.
Thank you, board members. The question I have of staff members, Ms. Bush, who will prepare the notice of action for the board?
Madam Chair, Tyler Newman will be preparing the notice of action, and I will coordinate the signature on it.
Thank you very much, Ms. Haley. I appreciate that assistance. Okay, those of you who were here for this matter are certainly welcome to stay through the rest of the board's meeting. If you choose to exit, you may do so. We just ask that you do so quietly so that we can continue with our agenda. The next item, we'll wait just a minute, make sure that we have the sound waves cleared. Okay.
Excuse me, Madam.
Yes, ma'am, Dr. Ponder.
I have another commitment. I have to leave the call. I'm already almost 15 minutes late for that commitment.
Okay. Thank you, ma'am. Dr. Ponder.
Thank you.
Thank you. Any other board members? We still have a quorum, I hope. I see 3, Ms. 4, Mr. Johnson, and Mr. White. Okay. I think we still have a quorum.
Yes, ma'am.
Thank you, Ms. Haley. Thanks for helping me keep track of this herd of cats. So the next item on the agenda is new business. The chair is not aware of any new business. The next item would be staff reports. And the first staff report is the status of appeals to circuit court. We've asked Ms. Bush to keep us apprised so that we know when the cases leave us, if they're somewhere in the court system, just their status. So Ms. Bush, go ahead, please, ma'am.
Yes, ma'am. I have nothing to report on where these cases have anything has tracked to. It is my understanding that the courts are very focused on moving their backlogs through. So I would expect that in the next 6 to 8 weeks, we may have more information, but at this time, I don't have any information.
Ms. Bush, do you know whether or not mediation has been scheduled in any of the Sandcastle matters?
No, ma'am, I don't know.
Okay. All right. Any questions of board members of Ms. Bush on the status of appeals to circuit court? Okay, the next item is status of LMO amendments. Ms. Dixon, I understand you're going to make that report to us?
Yes, Madam Chair. I'm happy to report that the first set of LMO amendments, the general set, will be introduced at next week's Public Planning Committee, June 2nd. So I invite anyone that's interested in hearing about what's coming forward to participate in that meeting or attend that meeting. Again, it's June 2nd at 3 p.m.
And Ms. Dixon, this is the chair. The 2 requests that the board made, I think January of last year, are those requests on the list?
Those requests would be concerning the definition for nano brewery, and the other one was regarding mopeds and scooters being considered outdoor commercial services, or I'm not sorry, other commercial services. Those 2 items are on the list of the first set of amendments.
Okay, thank you, ma'am. Any other questions of Ms. Dixon on that report? Okay, hearing none, we'll move on to the status of amendments to the BZA rules of procedure. Ms. Lewick.
So Diane Bush and I have met and have discussed some draft amendments. A red line edit of the rules of procedure was sent out for review, and some research continues on the appeals and public comment component to that. So we're still working. As soon as we have a draft, it will be in the next packet if it has gone through review.
Okay. Any questions of board members of Ms. Loic about status of amendments to our rules of procedure? Okay, hearing none, we'll move on to the waiver report by Ms. Loic. The board has been furnished with a copy of a written report, and to save some time, I would ask if there are any questions of that written report. Hearing none, we'll make that report a part of our record for today's meeting. We'll next move on to board business. At our one of our previous meetings, I think it was our board training, we discussed considering possible LMO amendments related to lot sizes and setbacks. The board had some concern about small lots and request for variances from setbacks, and I think from buffer standards as well. I'm going to go down the rotating list of board members to see if you have some discussion about this. Any recommendations for staff to consider, or just general discussion on this? Mr. White, your name's up first this time.
I don't have any questions.
Okay, thank you, sir. Mr. Johnson, any discussion or questions from you?
No, not at this time, Madam Chair.
Okay, thank you, sir. Mr. Fingerhut, questions or discussions from you?
Thank you, Madam Chair. No, I don't have anything right now. Thank you.
Okay. Mr. Walczak.
Nor I, thank you.
Okay, all right, thank you, sir. Ms. Loudermilk, questions or discussions from you?
None from me at the moment. Thank you.
Okay. And Dr. Ponder had to leave, so it's to the chair. I think our discussion had previously been about concerns about some of the small lots that we saw coming before us, especially those within a subdivision where there was not much room left on the lot for particularly a single family home. And we had been seeing some applications for increasing the footprint of a home when it had been extended to the full building print size, and to be able to have variances to the encroachments into the setback or into the buffer standards. So I think our general request would be to staff, to the LMO staff, those who work on LMO amendments. Ms. Dixon, I guess we're picking on you in this case.
That's fine, and I'm prepared to talk about it with you.
Great, great. I think we'd like to take a look at that. And Ms. Dixon, if there's something you want to talk about now, we're happy to hear that. Or if you want to make a report at another meeting, just let me know your preference.
Sure. Just what I was going to add regarding this topic was that what staff has found with regards to a lot of the variances you have seen over the last year or two were a result of violations that have been found, or a neighbor has complained about. And what we decided to do, or attempt to do, was to work on some educational efforts and outreach to inform the public what can and cannot be located in the setback and buffer, regards to fences and pools and patios, and try to get the word out there, because I think what's happening is, maybe some of the public are told they don't need a permit for that, but while they don't need a permit for it, they still have to abide by the LMO. So what we thought would be a great approach would be to do the educational outreach, put some stuff on our website, and see how that goes. And then also during the development review process, when developers are creating subdivisions, just being more proactive with reviewing their plans and letting them know, once, you're creating really small lots, And if you build to the setback and buffer, you're not going to be able to add a patio or a pool. So just trying to be a little bit more proactive in the development review processing, and see where that gets us. And if you'd like us to add it to the LMO list to look at, reducing setbacks or making minimum lot sizes, then we'd be glad to do that as well.
Okay. Having heard Ms. Dixon's report, any questions or discussions now from board members?
I have a question for Ms. Dixon.
Yes, sir. Mr.
This
Johnson,
is
go
Bob.
ahead.
Yeah, is there no way to effectively communicate with the contractors about this so they realize that there's restrictions?
Well, that's what we're going to try to do. We're going to try to get some outreach out there, put it on our website, potentially do, we're slowly getting back to normal, so hopefully we can do some in-person outreach efforts like we've done in the past, where we invite the public, contractors, developers to a training with the town here at Town Hall, and maybe go over some of these things with them so that they're aware of it.
I think that's great, and I would encourage you to continue to include the contractors and subcontractors, because they're dealing with it every day versus the general public that it only comes up once or twice when they're expanding their livable area outside their setbacks.
Yes, sir.
Thank you.
Anything else from board members? Ms. Dixon, this is Chair Bryson again. I would request that staff take a look at the size of lots with regard to the square footage allowed for residential homes, single-family residential homes, because what we're seeing, and the town council has raised questions about capacity on the island. What we're seeing are large, sometimes even mini hotels built on small lots, and I would make a request and see what other board members might say about it, that the staff go back and look at the lot sizes allowed in various zoning districts with regard to the size of houses, whether it's square footage or number of bedrooms or some other way of minimizing the impact on the, especially setbacks and buffer areas and protection of the environment as called out by our plan. So try to see if we need to reorder some of those LMO requirements so that we don't have large buildings intruding on setbacks and buffer areas, which seems to be happening. And that's, I think, what raised the board's concern. Any comments or discussions about what the chair is requesting?
No, I definitely understand where you're coming from, and I know what your direction is. Assure you that we do have something similar to that on our list already. I don't think it's for the set coming up, but maybe the second set, where we're looking at the sizes of buildings and the massing and setbacks and buffers, and so we're definitely going in the right direction.
Okay, thank you, ma'am. Any other board members' comments on what the chair was suggesting? Okay, hearing none, the next item on our agenda would be the board training. Ms. Lewick has a preparation of, I understand, maybe 30 to 40 minutes about how to conduct meetings. There's some board members who still need some time to meet the requirements. Those of us who do not need it or could be excused from the rest of the meeting or stay because you want to be more educated. And also understand, as Ms. Haley kindly reminded me, that we do have the opportunity to have online training, and she and Ms. Lewick prepared a wonderful list for us to link to for online training. And Ms. Haley, Ms. Lewick, can you remind me, I think it's a June 30 deadline to complete your training for the year, is that correct?
That's correct, June 30th.
So it goes by fiscal year. Anyhow, anybody who wants to leave at this point, board members. I'm sorry, did I hear somebody? guess not. But otherwise, I think, Ms. Haley, I think we still have a quorum. We can proceed.
Thank you, Madam Chair. I think I'm going to step out. I have my credits and actually I have a job, so I'm going to go back.
Thank you. And I should have asked, I apologize, any other business that board members know of before we move to this portion of our meeting?
Yeah, I know of one.
Yes, sir, Mr.
Earlier in the meeting, I made a motion to approve the minutes of 2 meetings, and I didn't realize that I wasn't at the second meeting because it really wasn't a meeting. It was a training session. So why did we have minutes and approve minutes for a training session?
Because it was a special meeting, and so we are required to take minutes of any kind of meeting that we have. Yes, sir.
Okay, well, I was on because I remember meeting on a Thursday, but that was several months ago. So I was confused, and I guess if you want to correct the record, I could withdraw the motion. You could do it all over again, or you just say, the heck with it. I don't know. I'm saying, I thought about it. I looked at my calendar. I said, I didn't attend the meeting on the 29th.
Okay.
And because it was I didn't need the training.
Okay. So I think to clean up the record, I see Ms. Bush popping back up on her screen, but I think to make sure that we have a clean record on this, that we need another motion to approve just the minutes of the special meeting on Thursday, April 29, 2021. A second and a vote on that. Is that correct, Ms. Bush?
Yes, ma'am.
Okay. So do I have a motion to approve the April 29, 2021 special meeting minutes from someone who was there?
Oh, none of us were there? I think they.
Well, I believe I was there.
Mr. White.
This is John.
Okay.
Oh, okay. Good.
Let's see if there's anybody left who can vote on it in addition to me. Mr. Johnson, were you there?
I believe so.
Can you second the motion?
I'd be happy to. I second the motion.
Okay. So, Ms. Hay, any more discussion on the motion? Ms. Haley, will you call the roll on that motion, and we'll see if we have enough people to vote on it.
Certainly, Madam Chair. Mr. White?
For the motion.
Mr. Johnson?
For the motion.
Mr. Fingerhut?
Abstain from the motion.
Mr. Walzak?
I guess I have to abstain also. Sorry.
Ms. Loudermilk?
Abstain from the motion.
Ms. Bryson?
For the motion.
Oh,
So we have 3 in favor and 3 abstentions.
What do we do, Ms. Bush? Dr. Ponder left.
I recall Ms. Loudermilk was at the training. Is that wrong?
No, I was not. I had hoped to be, and I had emailed Teresa. I was not able to make it.
Yeah, that's right.
Teresa, we may need you again for some direction. If we can continue the motion.
Well, there was no one's opposed to it. It's 3 to normally the winner of the tie is the winner.
That's in baseball. It goes to the runner.
Unless it's the 10th inning.
Yeah.
I'm about to run away.
This is Teresa.
I think it's a simple majority.
I think, as Missy just mentioned, I think it's a simple majority. I'm not an expert in Robert's rules, so I would defer to Diane. However, I do believe that, I know it has been our general practice for board members to abstain from voting on minutes at meetings that they were not a part of. However, I believe that Robert's rules does allow for board members to motion, second, and vote on minutes to approve as to form, and also rely on the accuracy of the board members that were present.
I'll go for that.
At the end of the day, the same thing, that the abstentions are not counted and that the motion carries by the majority.
Okay, great.
Yes.
Well, I just looked at the minutes, and the other person who was at that training was Dr. Ponder, and she voted in favor of the earlier motion. So With that having said, it sounds as though those minutes have really been officially approved now. So thank you all.
Sorry for the confusion, everyone. Sorry.
No, we appreciate your forthrightness. So, okay.
That's the way it is. Yep.
All right. So now, any other business before we move on to the training and excuse anyone who wants to depart? Okay, going once, going twice. All right, done. Thank you,
Thank
Mr.
you.
Fingerhut.
Thank you.
I'll
May
also
we
be
take
leaving.
a 2-minute break?
Yes.
I'll be
yes,
leaving. Thank you.
We'll take a 2-minute recess, and I will look to the screen to see.
I hate to say, who's staying on? Because I intend to do some online training.
I'm going to stay on the other participants.
Yeah, I'll stay on as well.
Mr. White? Okay.
Yep.
And in case you didn't hear me, I'm leaving. Thank you. Goodbye.
Yes, sir. Thank you, Mr. Walczak.
Bye-bye.
Well, the chair will stay on in case I'm not conducting meetings properly. I need to learn. So, but
I'm staying on for a refresher.
Okay. All right.
Just so you have a full audience.
Yes, ma'am. So Ms. Haley will take a 2-minute recess, and I will look to see when folks reappear at the screen.
Where'd my video go?
I think I hear you, Ms. Loudermilk.
There you go. I'm trying to come back on here. There we go.
Okay. There you are. And I see that Mr. Johnson and Mr. White are here. And I think Ms. Bush, is Ms. Bush back? And I see Ms. Lewick, and I should have said that too. I'm sorry, Ms. Lewick. I did see you. I see Ms. Bush's, I see her screen. There she is. All right. Oh, now Ms. Bush disappeared. She's there though. Okay.
But I don't need to talk.
I understand. I just want to make sure you were there and ready to go. I think, Ms. Lewick, we are all here who want to stay. So you may proceed.
We go. We have how to conduct meetings for the Board of Zoning Appeals. You guys should all know this by now, so there shouldn't be anything new. So the meeting covers all of this. We're going to kind of go through how the BZA operates, governing documents, our rules of procedure, what kind of applications come to the board, and kind of the overall structure of BZA meetings, such as the agenda and the meeting organization, participation, motions, and voting. So the mission for the Board of Zoning Appeals hears and decides appeals, grants variances from provisions of the LMO, reviews and takes action on special exception cases. So the LMO sections that most BZA cases refer to are Chapter 2 variances, Chapter 2 appeals, Chapter 5 development standards such as setbacks, buffers, parking, and then Chapter 6, the natural resources section related to trees and wetland buffers. So, as per the rules of procedure document, the BZA is a 7-member board appointed by the town council. The terms are 3 years, and no member can serve for more than 2 consecutive terms. We're a quasi-judicial body, so we act like a court, and we make a lot of decisions. The authority for the board is established in LMO Appendix A3. The board elects a chair and a vice chair annually. There is a conflict of interest clause in the rules that says that any member of the board who has or may have a conflict of interest must prepare potential conflict of interest form and file that with the secretary and provide a copy to the chair. At Diane's training, she provided that conflict of interest form. And then there are specific procedures for hearing those applications, of which I will go through individually on the next couple of slides. So that's basically the structure that are set by the rules of procedure, which we are currently looking at editing right now. So some of these terms may change. So variance, we're very familiar with variances and just heard one today. So the rules of procedure speak to variances in Article 7, and then the LMO speaks to variances as far as the process in Section 16.2.103(s). And a variance procedure is used to seek and obtain relief from the following standards. We either have the district standards in 16.3 zoning districts, except standards designating permitted or prohibited uses and setting maximum density. The use-specific conditions in 16.4 can seek a variance, as well as, and most commonly, the standards in 16.5, development and design standards regarding adjacent setbacks, buffers, open space standards, parking, loading standards, and fence and wall standards. So most of the variances are in that bucket. We also can receive variances from Chapter 16.6, natural resource protection for specimen tree and wetland buffer standards. And the procedure is right from the LMO. There's this little graph that includes kind of the variance procedure. So the BZA reviews the application and staff report, holds a public hearing on the application, makes a final decision on the application. The board's decision is based on the variance review standards and is always one of the following: to approve the application subject to conditions, or to deny the application. And the board's final decision is always in writing and includes findings of fact and conclusions of law separately stated, which typically, as we know, are included in the staff report, but in some rare cases, such as today, the board has to do all of those findings and conclusions on their own, which is why a couple of years ago we introduced those board templates for the particular cases. So we have a template for variances, we have a template for appeals, and we have a template for special exceptions. And those can come in handy, such as today. So again, the review standards for variance are the four standards that you are well aware of what they are, as we just talked about them. Criteria 1, that there's extraordinary and exceptional conditions pertaining to the property. Number 2, these conditions do not generally apply to other properties within the vicinity, and because of the conditions, it would effectively prohibit or unreasonably restrict the utilization of the property. And that number 4, the authorization of the variance would not be of substantial detriment to adjacent property or the public good and the character of the zoning district. So after those review standards are applied, then the variance can be granted by the board if it concludes that strict enforcement of the appropriate dimensional, development, design, or performance standards set forth in the ordinance would result in an unnecessary hardship. There are some limitations that are included in the LMO related to seeking a variance. The decision-making body may not grant a variance if the effect which would do any of the following: if it would permit a use that is not allowed in the applicable zoning district, if it allows the physical extension of a non-conforming use, or if it increases the density of a use above that permitted by the applicable zoning district, or you cannot apply for a variance from the sign regulations. And finally, a factor that's not to be considered is the fact that the property may be utilized more profitably should a variance be granted. So that may not be considered grounds for a variance. The next case that we could hear is a special exception. Since I've been here with the town, I have not had a special exception case. So I understand that they are rare since the 2014 LMO rewrite. We used to have a lot more special exception cases, and now we no longer do. So the process is outlined for special exceptions both in the Rules of Procedure, Article 8, and then also in LMO Section 16.2.103E. And it applies for any use identified as a special exception in the zoning district. Chapter 16.3 must receive approval of the special exception in accordance with the procedure and standards of that subsection before it can be developed under the ordinance. The procedure is again outlined in the boxes on the right here. The board will review the application and staff report, hold a public hearing on the application, and make a final decision on the application. The board's decision is based on the special exception review standards, and basically is the action then would be one of the following: to approve the application subject to conditions, or deny the application. Again, as with all of the board's decisions, their decisions should be in writing and include findings of fact and conclusions of law. Now, special exceptions have 8 review standards. I'm not going to read all of them because they're all located here on this slide, but the Board of Zoning Appeals shall approve an application for a special exception if the applicant demonstrates the proposed special exception and associated development meets all of those 8 criteria that are listed here. The next case that the board might hear is an appeal case. And the process for an appeal is outlined both in our Rules of Procedure in Article 9 or the LMO Section 16.2.103T. Who can file an appeal? A decision or written interpretation made by the official or other administrative official pursuant to this ordinance may be appealed to the Board of Appeals by any person aggrieved by the decision or interpretation. who alleges that the official or other administrative official erred in making the decision or the interpretation. So, and it further describes that the person who is aggrieved is if there is some special or particularized injury to that person or that person's property resulting from the decision or the written interpretation. There are a couple of types of appeal. Appeals of the following decisions or interpretations are heard by the BZA. There can be a minor deviation to a plan unit development appeal, a natural resource permit appeal, a wetland alteration permit appeal, certificate of a compliance appeal, and written interpretation appeal, or any action to enforce the provisions of the LMO can be appealed. Typically, we see appeals from written interpretations. Again, the application procedure for an appeal is on the right on this table. So the board will review the application, hold a hearing on the application, and make a final decision on the application. The decision of the BZA is based solely on the record of the appeal, as supplemented by arguments presented at the hearing, and also the appeal review standards. So the action on an appeal by the board can be affirmation of the decision or interpretation in whole or in part, modification of the decision or interpretation in whole or in part, or reversal of the decision or interpretation in whole or in part. And again, as all of the decisions by the board, it has to be in writing and include findings of fact and conclusions of law. So the procedures for an appeal include the review standards, and those are that they need to make a determination that either the official made an error in determining whether a requirement of the ordinance was met, the official made a decision based on a requirement not contained in the ordinance or appropriate town ordinances, regulations, or state law, or the official made an error in applying the requirement of the ordinance. And unless the BZA makes the determinations in the paragraph above, it shall affirm the official's decision or the interpretation. So those are kind of the procedures that the board hears. And then we go through some of the process for which to post meetings and conduct the rest of the board's business. So we are required to post a notice. The secretary gives the notice required by statute for all the meetings of the board, and that notice includes like publication in the newspaper, such as the Island Packet. We post meeting notices on the Town of Hilton Head Island's website. Also, we have a kiosk outside Town Hall, and we also send email notification to BZA members and the applicants of each meeting. And also we have other notice requirements. In the cases involving variances or special exceptions, there's a notice posted on or adjacent to the property. We also hold all meetings open to the public. Obviously, we have an emergency order right now for meetings that were operating during the pandemic. And then we also meet the requirements of the Freedom of Information Act, or FOIA, for all of our meetings. So we require 4 members of the board for a quorum. And if there are any agenda items when there is not a quorum, then they have to be postponed for the next meeting. There are powers and duties for the chair. All of these are outlined in our rules of procedure. But the chair is responsible for maintaining order for the board and beginning the meeting on time, abides by the agenda, is familiar with the procedural rules and our rules of procedure, keeps the board working together, explains the procedures, communicates the next business in order, allows the board members to speak at their will on the agenda items, and fosters board discussion, remains calm and objective, and keeps the meeting moving. And the chair also should be a voting member on the board, and should request a motion with grounds that includes facts and conclusions to be made. And again, we have those motion templates again that do help when the board needs to either amend a motion or amend some of the findings or conclusions that were included in a staff report. So the chair also has other roles to basically get the discussion to a vote. So the board or the chair is responsible to kind of pull the board to the question of the vote and usually restates the motion, requests polling of the members for the vote, and announces the result of the vote. Or our secretary will help with some of those items as well. So the rules of procedure call for that these are the basic kind of rubric for a general agenda. And that is typically what you would see on most of our BZA agendas as far as business items. So as far as the meeting organization, the chair introduces each business item, for example, like new business, old business, board business. And then the rules of procedure, as well as the LMO sections, contain specific procedures that I already went through for applications for variances, special exceptions, and appeals. And then typically we'll have a staff presentation on the application, including an analysis and recommendation, and board members then ask questions of staff. The applicant or their representatives also may make a presentation, and then the board can ask questions of that applicant. Following the presentation, the board may ask additional questions of both parties, comments from the public, if it's allowed, like on special exceptions or variances, but not allowed on appeals cases, would be taken at that time. And then there would be a motion and discussion by the board, clarification from staff if it was necessary, and then a vote on the motion. So participating in the meeting, all good board members should be on time and be prepared and review the packet materials, visit the site if it's necessary, ask questions, participate in the discussion, make a motion, second a motion, and vote. Executive session, we had that already recently. I guess it was the first time in a number of years that the BZA has had executive session. But our rules do account for executive session when necessary. So it can be called if a member determines after reviewing the applicable case that they would benefit from the advice of legal counsel. And up on the screen are some of the reasons for executive session. And I'm not going to read through them, but typically they would involve needing some legal advice related to a particular request. Communication with outside parties. This is also outlined in the rules, but there should be no communication in writing, orally, or by email by any board member with any other board member or any outside party regarding the substance of any matter before the board that is or may be brought to a vote other than during a public meeting. So no ex parte communications. And also, once a decision has been rendered by the BZA, there should be no further discussions on that matter, and all further communication should be handled through the town attorney. And basically all discussion should take place in the public meeting for any BZA matters. Communication among board members, again, should take place within the meeting. Even if there was a site meeting, we would have to make sure that we properly posted the meeting that's off-site to make sure that we're meeting FOIA requirements. Motions. We do have the motion templates that in advance of the meeting, if the meeting included an appeal or a variance or a special exception, then Teresa would mail out or send out in an email those templates so that the board would have those for the particular cases that are being heard at that meeting. And typically the motion includes that you're moving to do something. You can amend a motion. You can have conditions on a motion. But those templates are there to help the board clearly make a motion and meet the requirements that we're required to meet by law, that they're based on findings and conclusions. And voting. So board members must be present at the beginning of each case to be permitted to discuss and vote on the case. So if you were going to be late, and you join the meeting after a case has already begun, you would not be able to vote on that particular case. For an appeal from an administrator's decision, a majority vote of the entire board is necessary. So at least 4 affirmative votes to pass. So if we just had a quorum of 4 people at that meeting, then all 4 would have to vote in the affirmative for that to pass. However, the others, variance and special exceptions, is just a simple majority of the quorum is required. Silence is not a vote, so you do have to make an audible vote. And a tie vote is a lost vote as a majority was not met. And that concludes how to conduct meetings for the BZA. Are there any questions about any of that? You guys know this stuff already, so.
Any questions from board members of Ms. Loic?
I have a question.
Yes, sir. Go ahead.
When we have site meetings, is there a minimum or a maximum that can attend without destroying the privacy issue? I know we're not supposed to talk, but if there's two of us there at the same time.
Well, if there was, like, we often, encourage you to go to a site if there's a variance case, but we're not, when we ask you to go make a site visit, we're not asking you to go together with another BZA member. I mean, should that happen, you shouldn't really be discussing the case outside.
So we don't have to run. We don't have to run the other way.
No, you don't have to run the other way, but you just shouldn't discuss it among each other outside of the public meeting.
Okay, thank you.
Mm-hmm.
Ms. Loic, this is Chair Bryson. In response to that question, I think generally, and I would ask Ms. Bush because she's the licensed attorney in the room, but I think you have to have a quorum for it to be considered a public meeting. So if 3 board members are there, of course, we're not going to be discussing it, and so you have to have a quorum and be discussing business. So even if 4 members show up on site, as long as they don't talk to each other, is that a violation of the public meetings law in South Carolina?
I don't know the answer to that, Chair Bryson, without looking. However, I would say that it's, in terms of conflicts, always better to err on the side of being conservative. And certainly the big part would be the non-communication. I think that a quorum could all be attending the same party, but if you're not talking business, and probably it wouldn't look good if 4 of you gathered together, even if you weren't talking business, but a lot of conflict has to do with what the appearance is. And
okay.
So, I for example, I would discourage 2 of you riding together to the same site. I think certainly that, as Mr. Johnson said, you don't have to run away, and you can say hello and be cordial, but on the issue of whether or not it matters that it's a quorum, that I would have to look up. And Missy, unless you know the answer.
I can't speak with certainty, but I do believe that the quorum, we would have to have posted it as a meeting if there was to be a quorum. And so I guess to get into the question, if we were organizing a site visit in which we thought there would be a quorum, we would have to post it as such. Even if there was no business to be discussed, just that they would all be in the same place at the same time and there would be a quorum. So we would have to post that. But if it was just 2 individuals showed up at the same site because it's a variance request that's coming before the board and they both happen to show up at the same time, that's not a quorum. But no, they shouldn't be discussing the particulars with each other.
And one more follow-up question. I think also if you're on a site visit and either the applicant is there or representative of the applicant, contractor, engineer, architect, attorney, Or if there was a neighbor who comes by and wants to talk to you about the variance request, or sorry, the appeal or a special exception, then we're not to talk to anyone about the case. You know, and unless a law enforcement officer asks us to leave, and then I suppose we need to respond. But at any rate, not to talk to anyone about the case, either on the site or outside of the hearing process. Did I mislead anybody or misspeak on that, Ms. Bush?
No, ma'am.
Okay.
No, I agree completely.
Okay, thank you. Any other board questions about the training presentation or related questions? I don't hear anybody else. So thank you, Ms. Lewick, and thank you, Ms. Bush, for responding to our questions as well. And I see Ms. Haley and Ms. Dixon on the list for questions. So if there, I know Ms. Haley's still here. Ms. Dixon, if you're here too, thank you for standing by for us. Any other business to come before the board? If not, I'll adjourn the meeting at 5:02 p.m. Thank you all.
Thank you, everyone.
Bye, everybody.
Bye-bye.